Welcome to the Greens List presentation on the Victorian Planning Zone reforms. For those of you who don't know me, my name's Nick Tweedie. I'm a barrister on Greens List, and we have here a panel of also barristers on Greens List who work in the area of planning and environment. And what we hope to do this morning is to give you a bit of an introduction to the new planning zones which have been, which are about to be released or probably will be released sometime next year. Now, as anyone who's done planning law knows, the zone controls represent the fundamental building blocks of town planning. They are the primary control in a planning scheme which dictates what land uses can or cannot occur on a particular piece of land. Now, the current zoning system that we have was introduced at the time of the new format planning schemes at the end of the 1990s, the early 2000s, so it's been around for about 13 years. And what we have now being put forward by the current government represents the most significant change to the zonings, to any part of the planning regime, which has happened in about the last 12 or 13 years. The changes which are proposed range from benign to very, very substantial. And we're going to take you through the changes to the residential zonings, the commercial zonings, the industrial zonings and the green wedge zonings, and try and emphasise for you what the chief changes are going to be. Now, can I say at the outset that there appears to be two competing themes emerging from the zone reform. On one hand, you have the government touting the new reforms as a means of introducing a greater level of certainty in the planning process, a certainty which apparently has been sorely lacking. On the other hand, there is the zones are being put forward as a means by which to open up areas for a greater range of land uses and to encourage economic development and development particularly of retail uses. Now, whether those zones are successful in doing that will be a question that we will all be interested in addressing over the years. But there is no doubt that what they will do represents a very, at least on the face of them as they are now, represents a very significant change to the way in which this city in particular has been planned over the last 12 or 13 years. Now, the current position is that the zones, having been released in July of 2012 for what's been described as a discussion period, or a period for which people can examine them and make submissions. Submissions have been made, if anyone wanted to make them, to a panel which comprises, amongst other, Jeff Underwood and Chris Canavan QC. As I understand it, that panel has an undefined period of time to respond to the government, to make recommendations for any changes, and then sometime in the next year, in 2013, we expect the zones to be introduced. We expect them to be introduced by way of a ministerial amendment. In other words, it'll just happen. And the real question is going to be not just the final form of the zones, but obviously the land that they apply to. And that's particularly relevant in the case of the residential zones, as you'll hear, where there are effectively three categories of residential zone, ranging from the very restrictive to the very or not very, but ones promoting development. And obviously it will be very significant how those zones are applied to various areas of residential land in Melbourne. And at the moment, it appears that will occur basically by way of a negotiation between DPCD and the local councils. So it won't be, in that sense, a public process, a process by which everyone's invited to come and have their say and have an argument. Now, having said that, I'm going to introduce our first speaker, Tiffany Anchormen, who's going to take you through the residential zones. Now, Tiffany came to the bar in 2011. She came from the Supreme Court, where she was the associate to the Honourable Chief Justice Warren and also Justice Judd. She's currently practising again in the area, broadly in commercial areas, but with a focus on planning and environment, and she'll come and take you through the residential zones. So, Tiffany.
So To start with, before I get onto the residential zones, this is a list of the proposed changes. You'll see that some existing zones are going to be deleted, some new zones are going to be created, and then some amendments are going to be made to some existing zones. I'll be going through residential 1, 2 and 3 compared with residential growth, general residential and neighbourhood residential zone in the second column. So, it's proposed to abolish residential 1, 2 and 3 zones which are currently in planning schemes and introduce 3 new residential zones which are loosely based on the existing zones that are to be abolished. I won't be going in any detail through the amendment of the existing residential type zones. There's some as-of-right uses which are covered in the residential zones I will be going through. So the majority of the change is occurring where I'm going to be, in the zones that I'm going to be discussing. Similar changes are happening in the zones to be amended, so I won't focus in any detail on those. As I go through, you'll notice a couple of themes will become apparent. In all of the zones, there are new as-of-right commercial uses, even though these are residential zones. So some previously prohibited commercial uses and some Section 2 commercial uses are now as-of-right and won't require a permit, provided they fit within certain parameters in the table of uses in the zone. In terms of neighbourhood character provisions in the neighbourhood residential zone, which is loosely based on the residential 3 zone that currently exists, have been strengthened. By contrast, they have been weakened, or the focus has shifted in the residential growth zone, which is the current residential 2 zone. So that's the land that we would expect to see around activity centres, the high growth areas. I have taken the go-go zone, slow-go zone and no-go zone references from a 2009 Advisory Committee report. The previous Labor government appointed in 2008 an advisory committee chaired by Cathy Mitchell to look into residential zoning. So that's prior to the advisory committee that Nick referred to, which was appointed by the Liberal government and chaired by Jeff Underwood. The Mitchell report, as I'll refer to it, made recommendations in relation to 3 different areas and used the go-go, slow-go and no-go zone references. The 3 areas that were recommended were actually called the substantial change zone, or go-go zone, the incremental change zone, or slow-go zone, and the limited change zone, or no-go zone. So although these changes in relation to residential zoning appear to be very new, they are in fact based on, but not exactly the same as, a report that was commissioned under the previous Labor government, but was only recently released by the current minister. Another theme that you'll notice coming through when we go through the zones is that, as well as changing the focus of neighbourhood character to strengthen it in the no-go zone and weaken it in the go-go zone, the go-go zone housing policy objectives have also been weakened, and it's interesting to think how this might fit with housing policy, particularly in relation to housing density and housing diversity. And that is not something that was recommended in the Mitchell report. That's a deviation from that original recommendation. You'll also see that there is provision to put a lot of information into schedules to the zones, and that means that there is a localised approach so that councils, when they're determining what parameters to set for each zone, can specifically tailor them to their area, including the objectives and the neighbourhood character objectives. So what you will see is less uniformity across planning schemes. They'll be more locally focused through these schedules, is what we're anticipating. And because of those schedules and the diversity of approach that might arise, it's difficult to say how these zones will be applied and what the outcome will be. Because we know the skeleton, we can see what the zones are, but we don't have a lot of the detail, which will come later in the schedules. So to start on the relatively dry part of the presentation, we'll have a look at clause 3207, the residential growth zone. So this is like the current residential 2 zone. The purposes have changed. There previously was a reference to higher densities and making optimum use of facilities and services that were available. That's been completely removed. The provision now only refers to medium densities, and it's referred to in the following terms as to provide medium density housing at increased densities. So there's no reference to high density, which seems to be incongruous in terms of current housing policy for these type of growth zones, areas that are identified as being suitable for housing growth. The purpose relating to neighbourhood character, which from memory it was to encourage residential development that is compatible with neighbourhood character, has been removed, so that you'll see a weakening of the principles of neighbourhood character. However, because there is provision to include objectives to be achieved for the area in a schedule to the zone, and these will be determined by council in conjunction, we anticipate, with the minister and the department, then it may be that some of these neighbourhood character objectives go back in through the schedule, although there's no specific reference to neighbourhood character in the zone itself. Some new as-of-right uses have been put in, so Section 1 uses. Food and drink premises, you'll see that there's a floor area limit, and that's how we see whether it's a Section 1 or a Section 2 use. If you're over the 100 square metre floor area, then you do need a permit, you're in Section 2. That was previously in Section 2 in the old residential 2 zone. The medical centre previously was a Section 2 use. Again, it's only a Section 2 use if you exceed that 250 square metre floor area. And then you have office and shop. Office was actually previously a prohibited use in this zone. So what that means is that, provided you stay within those parameters, you will not need a permit to have one of these commercial type uses in a residential zone. Some others have been amended, and there are some newly prohibited uses. So what this means is that there is the potential to blur the distinction between commercial areas and these high growth residential areas. And in fact, you'll see that these same as of right uses appear in the general residential zone. So for the majority of residential zoning, as of right commercial uses will be available, and this could lead to a detraction from activity centres, lead to a reduction in commercial atmosphere because you have a less concentration, everything is spread out a bit more, and there is no means of assessment to determine whether or not the amenity impacts of these uses are compatible with the existing residential uses. Because they're as of right, there won't be anyone looking to see whether the amenity impacts are compatible. I would also note that many of the as of right uses are based on floor area, but whether or not that is a good indicator of the amenity impacts is questionable. For example, a medical centre not exceeding 250 square metres of floor area. Well, in terms of amenity impact in a residential area, it might be better to look at the number of practitioners that are going to operate out of that medical centre rather than the actual floor area as an indicator of how much traffic will be generated, whether there'll be additional parking. The operating hours won't be looked at. It's only going to be on floor area, so it could potentially become a situation where you just squeeze as many medical practitioners into that floor area as you can. And previously there hasn't been the incentive to do so. So it may be that the number of practitioners in a practice of that size would increase just to get in under the Section 1 use. The threshold lot size has been reduced from 300 square metres to 80 square metres. So what that means is that to construct or extend one dwelling on a lot that's less than 80 square metres, you need a permit. Previously that was 300 square metres, so therefore far fewer of these type of developments will trigger the need for a permit. And the Res Code standards in clauses 54 and 55, things like setbacks, site coverage, permeability, private open space, they can all be specified in the schedule. So the standards that are in the schemes at the moment can all be changed, and it's anticipated that they will be changed in the schedule to suit each council. Height controls in this zone, there's a maximum of 12.5 metres. The use of the word should implies that it's a discretionary height control, but again, specific maximum heights can be included in the schedule and they are mandatory. They will only apply to dwellings and residential buildings, interestingly, and not to the as of right commercial uses. So if you can manage to design a medical centre that is 250 square metres and 4 stories high, you wouldn't have anyone assessing the height controls because there's no permit required, and a building and works permit is only required for a Section 2 use. So there's just no height control on those as of right commercial uses. I'll skip through. I had included the actual zone. It is pretty dry and it is pretty small, so I'll skip through that. It's difficult to read. They are all on the DPCD website. We considered printing them out for you, but given these are only proposed and we're not even sure when they're going to come in, we thought it best if you were interested if you had a look on the website for yourself. So the general residential zone, the SLOGO zone, it's similar to the existing residential 1 zone. The purpose in relation to housing diversity has been removed, and the neighbourhood character objectives can be specified in the schedule, and you'll see that there's an encouragement that development respects neighbourhood character. That's similar to the previous zone, and the table of uses is the same as in the zone I just described. Again, the threshold lot size has been reduced, not quite as much as in the go-go zone, but it's down to 200 square metres, so again, fewer developments will be triggering the need for a permit. Res Code standards again can be put into the schedule. The maximum of 9 metres in height is again discretionary unless a height has been specified in the schedule. Importantly, when specifying height in the schedule, there is no maximum or minimum that a council can choose. So depending on the negotiation provisions with the minister when these schedules come in, it would be possible to limit everything to 1 story in theory, if that's what the council wanted to do, and if indeed the minister would accept that. This is the neighbourhood residential zone, formerly residential 3 zone. So in line with the objectives, this zone is anticipated to be predominantly for single dwelling neighbourhoods with limited opportunities for development. The purpose in relation to density, again, has been removed, and diversity. And the provision for objectives to be placed in the schedule is broader than in the slow go zone. Rather than just neighbourhood character objectives, there are objectives for the area, which is much broader. And you'll notice that the purpose is to ensure that development respects the neighbourhood character. So rather than a simple encouragement, it's mandatory type language to ensure that neighbourhood character is respected in these areas. The medical centre as of right use is included, the others aren't. And there have been some modifications fairly similar to the other zone. Interestingly, there are a number of things in the neighbourhood zone that can be specified in the schedule, and it is here that the schedules really come into play. One that I don't have up there is that in relation to subdivision, in the schedule it can be specified that, a minimum lot size can be specified in the schedule. Now that could be any minimum lot size, so it could be such a large minimum lot size that further subdivision is just not possible in that zone. In addition, the default number of dwellings on a lot is 2, unless a different number is specified in the schedule, but that can't be less than 2. The threshold lot size. Again, broad parameters for council to state a threshold lot size in the schedule. There isn't a minimum or a maximum. So it could be that any type of construction or extension of a single dwelling could require a permit, and that's something that hasn't been seen in these new uniform planning schemes. In relation to height controls, there is a 9 metre height control in the zone itself, and the language is mandatory, unlike the other 2 zones. And there is provision to specify a different maximum height in the schedule. Again, that's mandatory. So significant aspects of this zone can be specified by council in the schedules, and therefore it's likely to be a very localised zone that is specific to each individual council, in particular because if councils are able to specify objectives for the area, then they could relate to anything. And there isn't really any uniformity from council to council once you start having broad parameters like that in schedules. So that's the zones. There are a number of effects which I might get into in questions. I think I'll probably hand over now and we'll discuss some of the effects later.
Okay, well, our next speaker is going to be Andrew Woods, who's this gentleman seated here. Andrew's been at the bar since 2003, and he again has a practice which focuses on all commercial areas but with an emphasis on planning and environment work. And he's going to come and talk to you about the new commercial zones, which are a replacement of the existing business zones.
Thanks, Nick. I haven't actually used one of these before, so we'll see how we go. All right. So at a glance, we're looking at the deletion of the 5 business zones, the amendment of the 3 industrial zones, and the creation of 2 commercial zones, Commercial 1 and Commercial 2. What that means is that existing caps on retail and office floor space will be removed on land within those new C1 and C2 zones. Extensions to small strip shops for additional retail development will be permitted where they're within 100 metres of an existing activity centre. The B1, B2 and B5 zones will become the new C1 zone, and shop and dwellings are as of right in those areas. B3 and B4 zones become C2, where small supermarkets, which is up to 2,000 square metres, will be, and bulky goods and offices are as of right. Permits can be sought for retail premises over that size. So what those changes will mean, or could mean, because we don't really know with some of them yet, but perhaps new format supermarkets in those as of right areas. It'll be very simple for a retailer who's geared in the right manner to set up a shop that's under the 2,000 square metres. So they will, one would assume, appear in more locations. There might be some new players, there might be some of the existing retailers changing the format of the stores that they're offering. Offices are able to locate in industrial zones. What that might also mean, and one of the, I'll talk about the Productivity Commission in a moment, but one of the recommendations from the Productivity Commission, which is where these changes, some of these changes came from, was that a business shouldn't have to have, for example, its logistics in one place, its other storage in another, its offices in another. That business can now co-locate quite simply. Existing shop and floor space restrictions in B2 and B5 zones will be lifted, so there'll be a much greater flexibility of the uses of commercial premises in those areas. The caps on major and principal activity areas will be removed, so we might see the simplified further growth of places like Chadstone Shopping Centre. So they're the changes at a glance and what they mean in a general sense. Just to go back to where they came from very briefly, it's not just from the Australian Productivity Commission's report, but that's a significant precursor to these changes. That report was handed down in December 2011, and it discussed how planning and zoning affects retail in Australia, the impact of planning and zoning regulations on retail competition by looking at the overseas evidence, and other impacts of planning and zoning regulations on the retail industry. And it also looked at planning compliance costs for business and those sorts of issues, and the lack, as it was perceived, of certainty. So its recommendations, and these can be seen quite clearly in the amended, the proposed amendments. Recommendation 8.1, state and territory and local governments should, where they're able to, broaden business zoning and significantly reduce prescriptive planning requirements to allow the location of all retail formats in existing business zones, to ensure that competition is not needlessly restricted. In the longer term, most business types, retail or otherwise, should be able to locate in one business zone. So that was what I was talking about a moment ago, that the one business can have everything in the one place, which, as things currently stand, is more complicated. Recommendation 8.2, governments should not consider the viability of existing businesses at any stage of planning, rezoning or development assessment processes. So don't look at the businesses that are there and the impacts that this new proposed development will have on them. Impacts of possible future retail locations on existing activity centre viability should only be considered during strategic plan preparation or major review, not for site-specific rezoning or individual development applications. It's often said in the tribunal, in reviews of decisions of councils in relation to these sort of applications, that the viability of existing businesses is not a factor that the tribunal should take into account. This is the Productivity Commission saying it certainly shouldn't be, and that should be reflected in the scheme. Recommendation 8.3, the state, territory and local governments should facilitate more as-of-right development to reduce business uncertainty and remove the scope for gaming by competitors. State and territory governments should ensure third-party appeal processes within planning systems include clear identification of appellants and their grounds for appeal, and allow courts and tribunals to award costs against parties found to be appealing for purposes other than planning concerns. Those familiar to the tribunal will be either very happy or very upset to hear about that, but it's interesting. We're all familiar with non-town planning concerns being raised by objectors in the tribunal, and this is at a federal level, the Productivity Commission saying, well, the best way to stop that is open up the costs orders against those sorts of individuals. Certainly when acting for developers, I've made similar applications based on those sort of grounds in the past against parties, and I think there's already scope in the Act, but there's a practice that it just doesn't really happen unless it's in exceptional circumstances. That hasn't found its way into this, of course, because it's not the place for it to be to reside. And recommendation 8.5, state, territory and local governments should reduce compliance costs associated with planning systems and development approvals by implementing the leading practices identified in the Commission's recent benchmarking report on planning, zoning and development assessments, and I won't go into that, that report. So the intended outcomes at a glance are to implement those changes, those recommendations. So there'll be greater retail competition, promote business in Victoria, which will give the government feels a leg up for Victorian business over surrounding states, overcome the complaints that the B1 zone was too restrictive, remove floor space caps and simplify the type and number of commercial zones. So what does it mean on the ground? Well, here's a couple of examples. B1 was 1,836 hectares. The C2 zone will be 2,588. And the B1 zone, this is the third dot point, which allowed small retail supermarkets as of right, comprised 1,836 hectares, and now those supermarkets are allowed as of right in C1 and C2, IN3, comprising 6,824 hectares. So in real terms, you can see a significant change. The department itself spruiks these changes in the manner that's on the overhead there, which is a nice short description of how all of these work. I should say I've got a copy of a paper if anyone wants it. Just come up during the break. It's got all of the links to the DPCD pages and those sorts of things just for the commercial zones. But that's there for you to read in your own time if you so desire. And there's a description of the commercial 2 zone. So I'll leave it at that.